I'm Rob Tracinski. This is Symposium, where we talk about the ideas at the basis of a free society. My guest today is Anthony Sanders of the Institute for Justice and the author of a recent book called Baby Ninth Amendments. Thanks for coming on.
Thank you, Rob. It's great to be here.
Now, the Ninth Amendment is a cause that's a topic that's near and dear to my heart. So I want you to start by talking about what is the Ninth Amendment, and then what is the idea of a baby Ninth Amendment?
Yeah. Well, so a lot of levels there, because I'm sure a lot of your listeners, especially those who were smart enough not to go to law school, probably barely know what the Ninth Amendment is, and let alone know what this thing called the baby Ninth Amendment is. So the Ninth Amendment is one of the original Bill of Rights. It's a 10 Bill of Rights adopted shortly after the Constitution. And there is a huge debate about what it means. But the Supreme Court has largely left that debate to one side and hardly ever said much of anything about it, unlike all the other amendments that we know and love, the First Amendment, Second Amendment now even, Eighth Amendment. There's all kinds of nice protections in there that we're happy the courts enforce. The Ninth Amendment, though, has been very silent, and it says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, to some of us, especially libertarians, that sounds like they're saying that there's other rights in addition to those in the first 8 amendments or elsewhere in the Constitution that are also, at a minimum, pretty important, and you can't deny or disparage them just because you're listing other rights. However, there's all debate. There are people who, in good faith, I disagree with them, but in good faith say, really this is coupled with the 10th Amendment, which talks about states and powers, and it has to do with federalism, or it has to do with what was going on at the founding, and it was like a compromise between the anti-federalists and federalists. So there's this whole debate going on about whether it protects what we lawyers call unenumerated rights. That is, rights that are not enumerated in the Constitution, but are still constitutionally protected. So what happened in the course of American history, though, that is pretty untold story until now my book has come out, is that states have their own constitutions. States have been doing this since before the Declaration of Independence. They're older than the U.S. Constitution. Every state has its own constitution. Every state, not every state, but a lot of states have adopted multiple constitutions over their history. Some can't get enough of it. Georgia and Louisiana, I think, have done it about 10 times. But some states have stuck with their original ones. And over the course of U.S. history, states have taken the language from the Ninth Amendment and put it in their own bills of rights. Every state has their own Bill of Rights. And so I looked at that and I said, well, if it's in a state constitution, it doesn't have to do with federalism, right? Federalism is a misnomer at the state level. So what is it doing there? And the book is an explanation, an exploration about what they mean. And I come to the bottom line that they do what they seem to do, what they say. They protect rights beyond just those enumerated in the Constitution. And that actually solves a problem we can talk about how we protect all the various rights that we think are out there when you have a finite amount of space in a Constitution.
Now, that's an interesting thing, because it's one of the things you start with in your book that I liked, which is saying that, people think of, we have all these rights guaranteed in the Bill of Rights, and just how narrow the protections of the things that are enumerated in the Bill of Rights, free speech, freedom to keep and bear arms, freedom from search and seizure, that sort of thing, how narrow that actually is. I mean, think of how small a portion of your life that actually directly connects to, versus all the other things that we're doing throughout the day that we would consider part of our normal ability to say we get to choose and decide what we want to do. But that there's the whole infinite variety of everyday life is so much broader than can be written down in 10 amendments.
Yeah, the key word you just said there is infinite. I mean, when you really think about it, everything that you do, everything that all the individuals in society do, there's an infinite number of freedoms that we exercise. So in the introduction, I take a hypothetical American who gets up at the time she wishes. She eats what she wants to eat. She has a job that might be a job she picked over other options. She might garden in her front yard. She might do all these different things that are exercises of her liberty. And perhaps to some of us, like, who cares about gardening? I don't even have a yard. Why would you care about that liberty? Well, it's important to her. And some of them are obviously very important, like your right to earn a living. Another one that's very well entrenched in American history is your right to choose a school for your child. If you don't like your local public school, you actually have a constitutional right, although it's unenumerated, to pick a different school to send your child to. And those are all rights that, for the most part, are definitely not in the Federal Bill of Rights, and for the most part aren't in state constitutions as well. But we think they're important. And so how do we protect them? And this is kind of a puzzle that has happened over and over again when Americans have written their own constitutions. And one thing I want to emphasize for listeners, especially those who are into history, is we always talk about the Philadelphia Convention in 1787 and the draft in the U.S. Constitution, and then the few times it's been amended since then, and all the debate that went into that. Well, that has actually happened about 200 times in U.S. history. And just a couple of those relate to the federal Constitution, if you take the amendments together. But they've happened in state after state after state. And often when they've done this, they said, okay, we want a Bill of Rights. What are we going to have in it? Well, we want speech, religion, all these things are very important. Okay, we're going to put them in there. And if you read state bills of rights, sometimes there'll be little quirky things. Like in Minnesota, for example, there's a right to peddle what you grow in your garden, which is it's completely unique to Minnesota. There are other states with anti-monopoly protections are in a handful of states, for example. But if you start listing every right, those infinite number of rights, right, at a minimum, you're going to end up with a phone book. And literally, you could never list them all. So what do you do?
And there's also the problem of technological change and what rights do you have to what you do on the internet, when the internet didn't exist at the time that the federal Constitution.
How do you cover that?
Yeah, exactly.
That's a great point. How do you cover the future and how society is going to change? And so what a lot of states have come up with, in fact, this exact mechanism I talk about, the language of the Ninth Amendment, essentially, sometimes they tweak it a little bit in state constitutions. This has happened in 2/3 of all states now. The most recent was Illinois in 1970, when it redid its constitution, adopted this language. But other states have kind of different kind of language that kind of gets at the same thing, which is broadly protect rights. And essentially what you're doing is you have a Bill of Rights, and then you say, et cetera, at the end. Figuring out exactly what those rights are can be a complicated issue. But the whole business of government is a complicated issue, as is protecting those rights. And this is a solution, an unheralded solution, I think, that Americans have come up with.
Well, you mentioned in the history that there's also something of the baby tenths, that there were sort of a stepping stone to the baby Ninth Amendments was people putting into their constitutions versions of the 10th Amendment, which was much more about federalism, much more about saying, well, look, the states still have their proper sphere and the federal government doesn't interfere with that. And this was the states asserting their sphere, and specifically asserting their sphere of authority in order to protect rights.
Yeah, and that brings up an interesting issue that I think people who believe in limited government don't give enough credence to. And I think it's partly because these days we're so focused on the federal government, which is enumerated versus unenumerated powers. So we, folks like us who believe in some of the founding mission of the country, like to remind people that, the federal government is a government of enumerated powers. You have the Constitution sets out a number of powers the federal government has, right? Interstate commerce, running a post office, a few other things, but everything else is supposed to be left to the states and the people. Now, these days, because of the New Deal revolution, that's as a practical matter isn't very powerful. But we like to remind people of that. Well, but at the state level, it's unenumerated powers. And there's not much of an argument that states don't just have broad authority to regulate. No state sets up its constitution to say, okay, you do this, this, and this, and that's all the state government is going to do. It's just kind of assumed, like it was in the old British system, that where Parliament, just has power to do what it does, and so they can legislate accordingly. But a baby 10th Amendment, what that does is say, okay, we realize that states have a lot of power, and these early baby 10th Amendments would talk about the general powers, broad powers, which today would be called the police power that states have. But we recognize that's pretty dangerous, right? That is a lot of power that your state government has. And so we want to have this Bill of Rights, that usually it would be the end of, to be taken very seriously, to be accepted out of those powers. And then over time, they would combine this with this statement about unenumerated rights that I write about, and that even rights that we're not listing here are exempted out of those powers, because we recognize your transgressions, dangerous transgressions, they actually would say, these broad powers that the states have. So that's another way that Americans have tried to balance the idea of the police power with guardrails on that.
Yeah. So what now? The thing about the Ninth Amendment and the baby Ninth Amendments is they generally have not been enforced. Now, why do you think it is that they haven't been enforced? There's not a staple of Ninth Amendment jurisprudence out there.
Yeah. So the Ninth Amendment, with a couple small exceptions over the years, really hasn't been talked about even at the Supreme Court. And you can come up with your own conspiracy theory as to why that is. My great con law professor in law school said, he basically said they don't know what to do with it, and so they're just leaving it alone. I think that's mostly true. At the states, it's a little bit more complicated. State courts over the years have protected unenumerated rights, so rights beyond just those in their Bill of Rights, just like federal courts have. So some of you may know the history that early in the 20th century, the federal courts did some work in protecting the right to contract and other economic liberties. They also got into some personal liberties. And more recently, although the right to contract, unfortunately, has fallen by the wayside, for the most part, federal courts have protected some personal liberties, right to privacy and all that history, although not so much abortion recently. But state courts have done the same thing, and they've kind of been hit and miss. Like sometimes they'll use part of this the state constitution that's a due process clause, and that's a whole nother topic we could get into about what due process, substantive due process, how that is interpreted to protect unenumerated rights. But at times they have used these provisions, these baby Ninth Amendments, the Ninth Amendment, but they haven't done it very much. And so my big critique in the book is, judges, you can do this. There's a few examples where you really do give robust protections to what we recognize are important liberties through these provisions, but then you kind of forget about them. And so I'm asking for state courts to be more engaged with the text of their own constitution, to take these things seriously, and to show how, this is not going to cause a major revolution in, and forcing us down to some kind of Robert Nozick night watchman state. That's not what these provisions are doing. What they're trying to doing is balancing this very broad police power with these liberties that we all think are important, but unfortunately are all too often just left by the wayside.
You said that the reason why judges haven't picked this up is they don't know what to do with it, because there is a legitimate sort of question there of how do you have an explicit protection of rights that are not explicitly stated, right? So yeah, and I think now the cynical interpretation, and I'm never against taking a cynical interpretation of politics, but the cynical interpretation is they haven't used the Ninth Amendment because they know how many laws that require them to actually strike down. That the government does so many things, and professional licensing, and there's so many different controls and so many different things that have been passed over the years, that if you really started to take the Ninth Amendment seriously, you suddenly would be like, well, we're opening a Pandora's box where we're going to have to strike down everything, and as you said, go back to the night watchman state, or at the very least, we're going to have to become much more active in telling the state governments and the local governments what they can't do. But I also think, there is that conundrum there of judges like to stick to the law. And I think that's why they go say, oh, let's see if we can, they like to stick to something that's written down that they can pin it to. So that's why they say, well, let's protect this right by going off to the due process clause, because then we have something written down, something that explicitly says what we can do. And so I guess that raises the question that if you want to take the Ninth Amendment seriously, then you have the question of, well, what rights does it protect, and how do we tell? How does that not become just sort of arbitrary or subjective?
Yeah, and I think one thing I do in the book that some people might be surprised by once they make it through to this section near the end of the book is I spent almost as much time in the book saying what rights aren't protected by these baby Ninth Amendments, and you could, by extension, the Ninth Amendment itself, than are protected. I mean, you could have a provision, is theorize what you might write in a constitution. You could have a provision that protects, any right you might think of, right? You could just say all other rights are protected too, and they're judicially enforceable. Well, I can imagine all kinds of rights. Of course, there are positive rights. Now, we don't have many positive rights in American constitutions. The U.S. Constitution basically has none. And state constitutions sometimes will have, say, a positive right to a public education. There's a few other examples, but for the most part, we're into negative liberties, as they're called in the United States. Other countries have positive rights. Good luck enforcing those often, but they do have these positive rights enshrined in their constitutions. But that's not what these provisions do, and that's because Americans have understood that when you constitutionalize rights, you're usually talking about rights, that liberty rights, natural rights that we have, that when we come into society. And that's why they all say in the language of the Ninth Amendment, they're all applied in these provisions. They say rights retained by the people. That is a huge hint there as to what it means. What's going on there is what many of your listeners may remember from philosophy class, and that's state of nature theory. So some of you know the story told most famously by John Locke, but many others, that we can think about a time where we were all just individuals or families, and then we found it was more advantageous to come together into society. And so in doing that, we gave up some rights in addition for the security that society brings, but we retained others. Now, this isn't something that actually happens for the most part. Like, I am not saying because this actually happened either in the depths of history or, at a time the state constitution was written, that's why this applies. It's just a way of thinking about it, thinking about our rights that we have as individuals, and then that we, to some extent, give up when we come into society.
Yeah, I think the founding of, or the settling of America is the closest you will get historically to having something like that happen. Where
some of those are pretty close. You're right.
You had charters and you had agreements and compacts that they actually wrote down. But,
right.
For the most part, it is more of a thought experiment because, most governments do not have a history of being formed peacefully out of people.
Right. And then you have people are born, and, my son never signed the same document I signed. And so we have that problem. But when Americans have done this, right, there's a couple of ways you could do this in, say, in a constitution that's thinking about a society coming together. You could go the route of Thomas Hobbes, the author of Leviathan, who wrote just before John Locke. And he says, you give up everything when you enter into society because the state of nature is just so bad. You need to offload everything to this benevolent dictator named Leviathan, who's going to then take care of you. And then Locke comes along, and other theorists were of the same persuasion, and said, okay, we come together, but we don't give up everything. We actually retain a good deal of our liberties. That theory, not the Hobbes theory, is what's enshrined in our constitutions, not just the U.S. Constitution and not just these baby Ninth Amendments. But if whatever state you're in, if you're listening in the United States, you pick up your own local state constitution, I encourage you to do so. It's probably replete with this Lockean language about retained liberties, unalienable liberties, all kinds of other language like that.
You talk in the book about how that a lot of them have provisions that you think you refer to as Lockean natural rights guarantees, where it's very clear that Lockean language is in there.
Right. So you need to have that thought, and that, of course, is the same backdrop to the Declaration of Independence itself. And so that backdrop of a philosophy you need to keep in mind when you are interpreting these provisions. And so what that means is, what rights are protected by these provisions? Well, they're natural rights that we would have in a supposed state of nature. We give up some of them, but we retain others, and they are protected to the same extent. This is the most important part, to the same extent as those that are enumerated. So just about every constitution, I think the only one that's literally in all 50 state constitutions is freedom of the press. So you have your freedom of the press, and then you also have your unenumerated rights. And whatever those are, they are protected at the same level as freedom of press. Now, it doesn't mean that anything that infringes on that right is struck down, can be struck down in a court of law. What it means is it has to be taken seriously. The court has to look at the evidence. The court has to do what we call at IJ judicial engagement in seeing whether this, whatever restriction on your liberty is at issue is actually for a public purpose, it serves public ends, or whether it's just, a payoff to some politically connected insider, or literally doesn't make any sense. And then it will violate the Constitution.
Well, so we talk about how not everything that infringes on a right or limits a right would be struck down. So, for example, I mean, we've had some recent cases where you have libel cases that have been brought against people. So there is that limitation on free speech. You can say whatever you like, but you cannot libel somebody, and you will be answerable for damages if you libel someone. A number of cases, just recent libel and defamation, that have just recently been decided in the last few weeks or settled in the last few weeks. So there are those things where there are other rights that people have, like the right not to be slandered, not to be defamed, that might create a limitation on or mark where the edges of your right to free speech go, and the same might be true of other enumerated rights. But the other question I would ask about this concept of judicial engagement, because we're used to sort of a long-standing old legal battle, especially about the Supreme Court rulings, where the problem is we have judicial activism, which is 9 old men in robes, deciding what they want to impose on everybody else, or inventing all sorts of new rights that other people don't think exist. So you have judicial activism, where the judges are out there making the law and deciding what they think should be in the penumbras and emanations of the Constitution, versus judicial restraint, right? And that was sort of the old conservative argument about this. So we have judicial restraint, where the judges don't interfere and they basically let the legislature write the laws. And what, in contrast to that, what is judicial engagement?
Yeah, well, judicial engagement, we like to think, is a happy medium but between those two. So judicial activism, as you say, properly understood, and how it was originally used when it first kind of became an epithet, is judges, just going beyond what the law says and just putting their own policy preferences into action. And I totally agree that can happen. It does happen sometimes. But over the years, it got more and more to mean, I don't like what the court did, therefore it's judicial activism. Even sometimes when courts would uphold laws as constitutional, they're called judicial activists, for whatever that means. Judicial restraint, on the other side, is not taking the Constitution or the law seriously, and often not taking the facts seriously. So that I guess I would call that a more extreme judicial restraint. We often call it judicial abdication. Judicial engagement is in the middle, where a court will take, it doesn't sound very radical. A court takes the Constitution seriously, what the Constitution says. People took a lot of time in various constitutional conventions and in Congress hammering out exactly what to put in the Constitution. So we should take that text seriously, and also taking facts seriously. So some of your listeners may be probably unfamiliar with the reality that usually when you go into court and you argue that some liberty of yours is being violated, particularly an unenumerated liberty, but often a lot of enumerated liberties, the court will defer to the legislature in adopting the law that you're attacking, or the policy that you're attacking. And it may even suppose what the facts might be that would allow the law to be constitutional. So it will literally hypothecate what facts might exist that would make the legislature reasonable in passing this law. Whereas in a normal lawsuit, right, you bring your facts to the table, the other side brings their facts to the table. You have this thing called the rules of evidence that figures out what the facts are. A lot of that just goes out the window in some of these constitutional cases, and the court will then defer to what the government says the facts are and what the government says the law is. And that's fundamentally wrong.
Well, and there are some cases coming up right now about Chevron deference, and Chevron deference is we're not just going to defer to the legislature. We're going to defer to government agencies, to executive branch agencies and regulators, and say, well, look, they made a judgment about how to interpret this, how to apply this law. And this is the idea that it was a case named Chevron versus somebody or other.
Right.
But that's why it's called Chevron deference. But the idea that, we're going to defer to the agency's judgment about what the facts of the case were here. And instead of bringing the facts in and saying, well, did they actually in fact make a reasonable judgment? And there's some talk about that being reversed. But, you're correct that has been done, especially with regard to the legislature. And I think there's something in the structure of our government that kind of encourages the courts to take the easy out on that, because nobody votes for the Supreme Court of a state or the Supreme Court of the United States. They weren't really voted into office. They don't have a mandate from the people. The legislature has a mandate from the people. So they're, I think, understandably cautious to say, well, we want the people, those who represent the people, to have more of a say. But at the same time, that can mean having this sort of passive deference and imagining, well, maybe there could possibly be a reasonable excuse for doing this from the legislature.
Yeah, it's basically you understand some kind of initial deference to what the legislature did and the democratic principles that are behind that. Like I get that, but this is taking that and putting it on a lot of steroids. And saying, okay, we're going to defer absolutely on what you think the law is, and we're going to defer absolutely on what you think the facts are. Let me maybe give an example to help the listeners on how this works. We represented a few years ago a couple in Miami Shores, Florida, that had a vegetable garden in their front yard. That's one of the examples I gave earlier. And there was an ordinance in the town that said you cannot grow vegetables in your front yard. You can grow them in your backyard, and you can grow fruit and flowers in your front yard, but no vegetables. I'm not sure exactly where this came from, but this the very avid gardener we represented, she couldn't grow in the backyard because basically it was too shady back there. So she grew this beautiful vegetable garden in her front yard. The city said you have to stop, and they had to rip them all out. We went to litigation about it. We claimed that the Florida Constitution in various ways protects this unenumerated right. And the court said, well, we have to defer to what the city council thinks is best in how this looks. And all they were doing is trying to make a aesthetic judgment about how the neighborhood is. And so it's rational for them to forbid them from growing vegetables, but not fruit or flowers in their front yard. I mean, that encapsulates the kind of deference that I'm talking about, where it's not like, okay, we're going to give you the first bite at the apple, so to speak, and making the argument that this is constitutional, but we are going to close our eyes to any alternative viewpoint.
Right. And it basically ends up making the guarantees of individual rights in this expansive way kind of a dead letter, because anybody can make a claim or an argument that, oh, well, we really have to control this. I mean, you have some great examples in there about food trucks, right? And oh, well, we can't have these food trucks everywhere. We have to have a law, and you can come up with rationalizations for it. But in the end, it's clearly what it's coming from is, well, there are existing restaurants that don't want competition from a cheaper alternative. Now, the big issue with the Ninth Amendment, though, that I think that causes this to be contentious and also causes it to be a matter of reluctance to even step into it is a friend of mine once put it this way, that the Ninth Amendment amounts to the phrase insert political philosophy here. that in inviting judges to think about what other rights there might be that would be deserving of protection, it basically asks them to refer back to a political philosophy that tells them what rights we have and what the legitimate powers of government are. Now, I think you make a case, and I think I agree with this, that basically that Lockean natural rights theory is the official political philosophy of the United States of America and of most states, that it's written in there. There's so many references to it. It's clear that that's what they had in mind. And Jefferson said, in writing these things into the Declaration of Independence, he was not trying to innovate anything. He was just trying to, basically capture the consensus of everyone at the time.
Right.
But at the same time, you talk about this, and this goes to what you're talking about, the dilemma of not wanting to say this mandates a night watchman state, because there's a sense that if you were to say, well, here, look, this Lockean natural rights philosophy is the basis for interpreting this, there's a concern that if you're going to ask people to take the Ninth Amendment seriously, you have to then go all the way to the Lockean sort of libertarian small government utopia that maybe some of us would like. That would make people reluctant. But at the same time, on the other hand, to have a liberal society, to have a free society in any meaningful sense, you do have to have some protection of unenumerated rights. So basically, how do you get people to take the Ninth Amendment seriously as a keystone of a liberal, a free society, while also dealing with the fact that people don't want to, or it's unrealistic to expect them to want to go all the way to the smallest of small government?
Right. Well, I would tell the critics such as your friend that there is no perfect way to structure a constitution, whether it's the U.S. or state constitutions. There are other ways of trying to get to a liberal society, but their criticism isn't with us trying to make these arguments in court. Their criticism is with who wrote the Constitution, and this is what we've came up with on how to protect rights in America. It is perfectly reasonable to say that a better way to protect rights is, say, through the British system. My own podcast hosted a couple weeks ago a couple British academics who have written a book about how the British Constitution is actually a good system of government, where Parliament basically is an ongoing Philadelphia Convention that is always exercising its sovereignty every time it passes a law. And Britain is still a fairly free place to live. I actually am a British citizen and enjoy my freedoms when I go there, although I much rather the American system. And you can argue for other ways of structuring it, but this is the decision that we've made in America, is to protect rights through enumerating them and then through broadly protecting them. We have other things, right? We have separation of powers. We have federalism. We have other parts of constitutional law that also protect these rights in a more indirect fashion. So to the critic who says, well, the Ninth Amendment, it could be used to open up all kinds of things. Sure, right? As I said, judicial activism properly understood can occur. I get that. You could have a judge, sometimes conservatives will talk to me about these issues and say, well, you could have a judge who just says, welfare rights all over the place, and they're going to institute socialism through the language of the Ninth Amendment. Yeah, okay, but what's the trade-off? Is the trade-off we just don't have any rights protections at all? We don't allow judges to protect any rights because we don't fear what might happen. I fear more what the legislature might do if we don't have that bulwark there of judicial review. And so, sure, that's an interesting way that we could structure our state governments, but it's not how we've done it.
Yeah, and now the other thing that has come up now, by the way, my friend's statement about that was not a criticism. He was in favor of it, but
okay, great.
It is I know what I was trying to get at is it is taken as a criticism by a lot of people to say, look, you can't have just judges ruling on their personal philosophy. But also it's to address I think the reluctance that people have to take the Ninth Amendment seriously, because it seems like it would then lead to an end result that they don't want. And I guess that's the other answer to this that's been brought out of how do you limit this is one that I have certain discomfort with, and it came up, I think, recently in the Dobbs decision on abortion, which is the idea that, well, okay, look, a right doesn't exist unless it's sanctioned by tradition, and that was essentially what the conservative majority in that case boiled down to, is to say, well, look, we can't find that there's a traditional recognition of a right to abortion, so therefore it doesn't get protected. And they're using essentially, now I said, it involves insert political philosophy here. I think their sort of operating political philosophy is traditionalism, right? Very conservative, very, very appropriate for conservatives, that if it's sanctioned by tradition, if it's hallowed by tradition, then it's protected. And, so that's a different way of doing that. Now, I think that also is a very limiting way of doing it, because, as we said before, part of the purpose of the Ninth Amendment is to recognize new things will come up.
Yeah, that the Dobbs, both the play between the Dobbs majority and the Dobbs dissent, I think are really interesting in ways much more than abortion, for what each of them get right and what, more importantly, what each of them get wrong. So the statement about history and tradition and this test that they have, I mean, I think that's more cynical and more correct way of looking at that is that it's an excuse to not recognize any new rights under unenumerated rights at the Supreme Court. And that's because they don't like this whole idea of substantive due process or just courts protecting unenumerated rights at all. But history and tradition is nowhere in the Constitution. It's definitely not in the Ninth Amendment or these baby Ninth Amendments. It's really just putting the brakes on courts doing things. The baby Ninth Amendments, we can talk about other provisions of constitutions, but they, for example, they say retained by the people, but retained doesn't mean history and tradition. It means, again, this whole idea about you have natural rights and you come into society. So going forward, looking at history and tradition, I fear there's going to be hardly any rights that the Supreme Court majority is going to recognize, because there's always an excuse. Well, it's not exactly this history and tradition. Another part of that test is that they have to get to a very low level of description, because otherwise you might have all kinds of rights. So they say that they get so wrong in the Dobbs majority. Whatever you think about abortion, by the way, they get this so wrong. They say, well, it's argued that there's a right to bodily autonomy. I mean, who are you kidding? Of course there's a right to bodily autonomy. Does the government, could it just come take your arm or your an internal organ, and like that doesn't violate some unenumerated right? Of course it does. But they said, well, if we recognize that, then we have to get into prostitution and drug use. They might be aspects of that bodily autonomy, and we're going to have to adjudicate those things. And so instead, we're just not going to recognize any of those rights at all, which gets it in entirely backwards. Again, whatever you think about abortion, which would be a subcase of bodily autonomy, where obviously there's different analysis there.
Yeah. I mean, I think that one of the key things there is this idea of, we mentioned earlier that the word infinite is important. That your freedoms are infinite in the sense that, or I would say, in the literal, not necessarily in the literal sense of infinite, but that they are unlimited, they're open-ended, that there's any number of things that you might want to do that you have a right to do.
Yeah.
And then as in contrast to that, the original, and we go back to the original arguments of the Constitution about whether we should have a Bill of Rights. The argument against having a Bill of Rights was, well, look, we only gave the government enumerated powers. We gave it very limited powers. So therefore we don't even have to spell out that the things the government can't do, because we only gave them a few powers. So the idea is the government's finite and the rights of the people are infinite is really the sort of the mentality that was behind all this. My favorite quote on this, what is it? This is from James Madison. It says, the powers of the federal government are enumerated, and it follows that all that are not granted by the Constitution are retained. And the Constitution is a bill of powers, the great residuum being the rights of the people. And that formulation of the great residuum, I like. That's the retention of the rights.
Right.
And, I do think that, even if you can argue about what the what the specific rights are and how you figure out what's connected and what government is allowed to do. But if you want to have a free society, you have to have, to some extent, this outlook of government has limits and the people are presumed not to have limits. You have to have some idea of that great residuum at the basis of a liberal or of a free society.
Yeah, and that residuum is exactly what's placed into our constitutions, whether it's the Ninth Amendment, other provisions of the U.S. Constitution, or in state constitutions. We all have this sense that the government should have a limited sphere, and the rest of us can do whatever we please. There's lots of different ways you could structure that, but over the course of U.S. history, as I hopefully show in the book, we've kind of settled on this way of doing things. It's just that unfortunately the judges, for the most part, haven't gotten the message, and hopefully they can get a little bit more of a one now.
Now, you also talk about the fact that the baby ninths are popular.
Yes. Oh, I'm glad you brought that up. That's something I really try to hammer home in the book, and actually came out through writing. It came out more and more. This underlying lesson from learning this history, that it's not that unenumerated rights are some weird exception to U.S. history, which if you read either the majority or the dissent in Dobbs, they're saying like, well, some of these rights we like, but we don't like this one. And so those are special. And then the dissent says, well, we like bodily autonomy, but right to contract, that was crazy stuff in the past, and we're not going to do that anymore. Actually, unenumerated rights are fundamentally American. They're popular. They're normal. They're all over the place. Now, how we protect them, we can talk about the edges of, where to draw the line and how to word those protections and how the court should fiddle around the edges with that. But the backdrop is that protecting unenumerated rights is a normal thing to do. And once we accept that, I think we see what the courts and the legislatures do in either in protecting those rights or infringing on those rights. We see it all a lot differently.
Well, I definitely hope that your book will have that effect of bringing some more discussion on this and maybe opening people's eyes to that as a way of looking at things, because I think the Ninth Amendment, there's all the legal arguments involved in the Ninth Amendment, but I think that mindset behind it of government is finite, the people are infinite. If I were to boil it down to one phrase, I think that mindset is the most important thing for people to grasp, and I think that it is sort of the implicit popular American creed in a lot of ways. So thanks so much for coming here and talking about this.
Thanks so much, Rob. And if the greatest thing about this book is if people are interested, is it's available for free if you want the electronic version. It's also a reasonable price otherwise, published by University of Michigan Press. So just Google it and you'll find the link.
And it's called Baby Ninth's Amendment. Again, thanks for coming on.
Thanks so much, Rob.
I'm Rob Tracinski. This is Symposium. My guest today has been Anthony Sanders of the Institute for Justice, talking about his new book, Baby Ninth Amendments. Go look it up. If you liked this discussion, please hit like on YouTube or subscribe to us on your favorite podcasting platform. And you can always find more discussion about the ideas at the basis of a free society at symposium.substack.com. Thank you for joining the conversation.